Good afternoon, everybody. I'm Gillian Sadler, Vice Chair of the Ulster Society, and you're all very welcome to the latest in our series of webinars with our legal partner, A&L Goodbody. Feedback from members for this series continues to be really positive, and thanks to A&L Goodbody for their time and expertise and for keeping us all informed on various topical legal matters. So like all of our webinars, we will be recording this session and it will be available on our website, charteredaccountants.ie/Ulster, along with the previous webinars in the series with A&L if you want to catch up on any that you might have missed. For today's webinar, John Tucker will be focusing on commercial property leases and highlighting his top 5 issues for us to look out for on behalf of clients, including rent reviews and insolvency risks. John is a partner in A&L Goodbody's real estate team and advises many of our local insolvency practitioners in relation to property matters in both public and private sectors, including all aspects of specialist landlord and tenant advice. Please feel free to put any questions for John into the Q&A box at the bottom of your screen. Q&A is now open, so you can type them in at any point during the presentation and we will come back to them at the end and pick them up. I would ask you to keep your questions general. John can't answer specific legal queries during the webinar, but if you do have any further detailed asks of him, you are more than welcome to contact him afterwards. So I'll hand over to John to get us started. John, you're very welcome, and over to you. Thank you.
Thanks very much, Gillian, and good afternoon, everybody. I'm just going to share my slides with everybody. Hope you can all see those. So yeah, I thought for the purposes of this afternoon's session, and thank you for joining on what is a nice day here. I'm sure you have other more interesting things you could maybe be doing with your lunchtime. But I just thought for this afternoon's session, I've maybe tried to focus on the aspects of commercial leases that are maybe most relevant to yourselves as professional advisors. And try to work through really how we can add value to client conversations and discussions around commercial leases. I'm sure a lot of you will have clients for whom their property interests are some of their biggest assets, whether it's the goodwill attaching to a location that they're at, or just purely in terms of financial value. And so much of our practice of law in Northern Ireland does come back to property assets. That something that I thought would be worthwhile just going over, and I suppose really focusing on leases. That's where we would see sort of the majority of our work in this sector. Ideally, I'd thought about doing this at the start of either the financial year or the calendar year as a bit of an overview of the year ahead, looking at lease milestones, looking at key dates and forecasting issues around that. But actually, the more that I looked at it, the more I thought it actually really doesn't matter where in the year, the calendar year, that look at this. And the more I looked at it, the more I thought actually, a lot of yourselves may be involved with lease review or negotiations even before it even reaches my desk. And I suppose I wanted to just focus on particular areas of financial impact and business planning rather than just sort of pure technical property law, and to work through things that might be of benefit to yourselves when advising clients and of benefit to clients when we're working together as advisors. So I'll try to focus on both like tenant and landlord provisions, because I know we'd probably act on both sides of the fence. I probably tend to slip back into tenant focus quite a lot, because that's usually where we see a lot of the impact around business tenancies, which is item 2 on the agenda. But I'll try to keep it balanced, because I appreciate that we'll have clients in both parties. So just in terms of agenda, I wanted to look at key lease date forecasting. What that really is just maybe if we're doing an annual review or a periodic review of clients' affairs, that we might want to have a quick look at the lease, or when a lease is completed, have a summary of key dates that sits alongside it that we refer to every so often, and just the impact of those dates and what might be needed around advice. And then to look at the business tenancies order, and that links back to sort of dates and renewals and how that all works. And then I thought that led quite nicely into negotiating heads of terms. So again, if you're looking at the rebasing, leases, regearing, if clients are sort of business planning for the next 5 years and premises are part of that, how you can add value there and what things to look out for. And then to look at future risks. So in a previous version of this, I might have focused a lot on insolvency risk, impacts coming out of COVID, anything around reducing space, working from home, that type of thing. Actually, at the minute, we're sort of more focused on the impact of ESG and particularly environmental requirements for property and what impacts that might have, both landlord and tenant side. And then there'll be time for some questions at the end as well, as Gillian said. So one of the other things that sort of prompted this topic of conversation, I suppose, was we talk about the new code for leasing business premises in England and Wales, which is actually a 2019 code. There's nothing really new about it, sort of 5 years on, but we still talk about it as the new code, and there's actually no equivalent in Northern Ireland, and no helpful reference point for professional advisors. So essentially what the code in England and Wales does uh, is to set a sort of a standard of types of content for clauses and leases, what can be comprised in heads of terms, what's best practice in terms of negotiations or sort of standardized terms within leases like rent review or break dates. And the objective of it was to improve quality and fairness of negotiations of lease terms, to sort of cut down on lost time negotiating around things that there should be an agreed sort of centre ground on, and make sort of drafting process more efficient. And I suppose the application of it doesn't apply in Northern Ireland, and our hope was that it would be adopted all the same as a point of reference, but partly because of when it came in and COVID kicking off shortly after, it never really got off the ground. And I suppose the idea was that if the property industry here were able to adopt it and accept it as general principles, that would help in terms of how we all advise our clients, because we would know where the centre ground is and be able to refer to that when the document landed in front of us, and we could say whether it was reasonable or not. So in the absence of that, I suppose today I just wanted to give you a bit of a run through, and as I say, I thought the idea of using key lease date milestones or forecasting might be the best way to kind of frame that. So you might look at this list and think, term commencement date. I mean, there's no magic in that. It's just the date that the lease commences, but there are particular implications around that, particularly in relation to stamp duty, which we'll look at. Same with rent commencement date. Again, that should be fairly straightforward. It's just the date that rent begins to be paid. But the issues around that are more so around rent-free periods that begin on the term commencement and end on the rent commencement date, and how you can best protect those for clients so you don't end up eating into those sort of unintentionally. I'll focus quite a bit on break dates, because I'm seeing more and more sort of litigation around that, and more concern really, and less clarity on drafting, when in fact, whilst we don't have that 2019 code, we should be moving to a position of more clarity rather than less. Rent review dates then as well, again, trying to focus on the sort of financial aspects of leases. If you're reviewing outgoings for the client or future costs, trying to forecast, and there's a rent review coming up, which has no cap, for example, what that looks like and how that can be navigated. And then termination date, again, a couple of war stories just to share there from recent experience, again, where something that in the past I feel it used to be treated as sort of fairly standard termination date, a function of time, lease end date, is now more open in a more sort of litigious environment, to difficulties arising. And then options to renew and preemption rights, again, not something that we see a lot. And I thought just to flag again sort of specific risks around that. So a very quick practical point to start off with around interpretation. I have this little snapshot on my desk printed out, and stuck to the side of my desk, because I refer to it so often around ascertaining specific dates in leases and constructing dates when they're required. This really focuses on precise break dates, as you can see from the heading, but it's useful for any dates in leases, and it's this sort of interpretation of when a date runs from and including, or when it begins on and includes a date, and the examples are there. So I thought it was just handy to include. particularly important when it comes to serving a notice for to exercise a break or on termination of the lease. Really key that those land on the right timeframes and the right dates and not too early or too late. And so it's sort of critical to get that interpretation right at the outset. And say that's something that, really is for us as lawyers to deal with and interpret. But quite often what happens is a client will come to us and they've already sort of missed the date because they've misinterpreted themselves and haven't reached out to us to check it in the first instance, which is understandable. But again, just thought I would include it in the notes as a bit of an aid memoir for everybody. So the term commencement date then, really the impact I want to flag here is just around stamp duty. And I think I always feel like stamp duty is one of those grey areas that sort of falls to the lawyers to complete at the end of a property transaction, but really is probably more an area of your expertise in terms of the tax implications. Obviously, we normally take primary responsibility for completing the SDLT returns and completing those. So there's an opportunity of it sort of fall between two stools there, but usually falls on our plate. And I suppose the issue with term commencement date, just if you're advising around it, is that whilst the lease might be dated at a certain date or be seen to commence on a certain date, whether or not that is in fact the effective date for stamp duty purposes is another question. And when I first qualified, we had 30 days to lodge stamp duty returns, and it's now down to 14. And it's funny how quickly those 14 days can pass. Particularly if you're as I'm going to go on to here, just around substantial performance, if you're sort of late to the party and late to be told by your client that they have substantially performed. So I suppose it really just to flag, if a client takes access to premises, they get keys early because they've got a good relationship with the landlord, or maybe they're in agreement for lease and they take access early pursuant to that, whether that's as licensee or otherwise, and where normally stamp duty wouldn't attract to a licensed relationship, if they've sort of substantially performed the lease. And they put on the slide there some more detail around that, and an example of freehold land as well. HMRC really look at taking possession to be whenever the keys are in their hand and the client's entitled to occupy the property. It doesn't really matter how that is dealt with or documented. And so I suppose it's just, if you're advising clients on it at all, or if you're involved heads of term stage around leases, or a question is asked of you, it's just to make that clear, because penalties can be just easily avoided by having the conversation. So if you've got the keys early, it's sometimes people try to hide it from their solicitors that that's happened, but it's important just to say that you've got them, and the stamp duty return can be lodged with an effective date of that date to keep everybody right, and it makes really no difference in terms of completion of the lease. I actually have one at the minute that I was dealing with this morning where they took keys sort of 10 days ago now, and we really need to get the SDLT return lodged, but the client doesn't want to pay without the signed lease, and it's agreed, but the landlord still hasn't signed. So that is another sort of cautionary tale, I suppose. It's all very well maybe taking the keys early, but if you do that, you're going to have to be prepared then to maybe put your money where your mouth is and pay the stamp duty. So I'm trying to sort of corral them at the minute to submit it and pay, so they don't incur a penalty. But ideally your lease would complete at the same time. But it was really just a flag that can be an issue, and if a lease comes in front of you, the term of commencement date is not necessarily the date that they first took occupation, if that's relevant for any other advice that you're giving. The only other points I wanted to mention then on term commencement date were really around interpretation of other dates, particularly break dates, which I keep coming back to, and rent review dates. Quite often, depends on the drafting of the lease, but quite often those will just be defined as the third anniversary of or the fifth anniversary of the term commencement date. Our preference as a firm, I suppose, would be to sort of leave a blank space and then to insert the actual date at the point of completion, and we'd have backup wording that would say, being the third anniversary of the term commencement date. The only issue with that is sometimes those can be missed and those blanks can't be filled in, which is hard to know what is worse in terms of interpretation point of view. But it's just the relevance of that. And again, it was in my head, particularly because we had a late year this year. And for a couple of days before the end of February, I was telling my team, look, be really careful about completing a lease on the 29th of February. Because, if you look at it, it's very easy just to complete. And then a few days later, when you come back to fill in your blanks, realize that your break date isn't capable of being exercised because it's the third anniversary of the 29th of February. And I know that has happened to another law firm in Northern Ireland where there was a claim on their insurance around that. So it's, again, just keeping that in mind, again, more for us as the solicitors, but just something to consider if you're advising clients, or for your own leases, or if you're dealing with it in your own personal capacities. And then the importance in terms of the business tenancies order. So again, if you're a tenant, we're very fortunate to have the protection of the business tenancies order in Northern Ireland, and you want to protect that protection. So you want to make sure there's clarity around dates and things if you have to serve notices pursuant to that order. So the rent commencement date, then again, that was just sort of differentiating this from the term commencement date. And again, I was thinking about this in the sort of context of you looking at a lease for a client, or looking generally at their business for the year and trying to look at milestones when there may be payments required or increases, or any advice that needs to be given around sort of financial hygiene. And I suppose the one point in that was just, again, if you're involved at heads of term stage, and there is a rent-free period, so it's a term commencement date and then a delayed rent commencement date, just making sure that that is protected. That, again, if your client takes access early by way of taking keys or starting initial works, that would eat into their rent-free period. So just to make it clear that they get the full benefit of that. And then, again, just to make sure that the interplay with the rent review dates, that there's no impact on other dates just by the virtue of the fact that your rent commencement date is different from term commencement. We see that a bit in people can be tripped up where they've made a date, referred it back to the term commencement date when it should have been rent commencement, and vice versa. So just to flag that if you're reviewing or advising. So break dates is where I wanted to, I suppose, focus a wee bit of time, because, as I say, it's sort of becoming more and more area of contention. They are very strictly construed and interpreted, and I said there is a time for pedantry, and really is a time to be very pedantic around how these are exercised. So I suppose in context, like, break dates are very useful to have, particularly in the current market, where you may have a client who wants to take premises for 10, 15 years maybe, but just isn't sure how business is going to be, and wants to build in, an option to break and to terminate the lease at different periods. We usually see those either 3 yearly, mostly 5, so maybe 5th, 10th, and at the end of the term. For break dates, but there is a tension between landlord and tenant and the interests of both when it comes to break dates. So the tenant obviously wants to make it as easy as possible to serve their notice and to exit the lease without any undue costs. The landlord comes at it from a slightly different angle, where they really want the tenant to stay, so they have the security of the rent, and therefore, quite often the drafting can be quite tricky in an attempt to trip up a tenant and catch them out. There's a whole sort of cottage industry and legislation around missed break dates, or incorrectly served break notices. And so I've said there, really, that clarity is key. And again, one reason why I wanted to mention it in this forum is really, a lot of the risk would be around sums that are payable. And so the third bullet point there is sort of an extract from the code that I mentioned. That would say, unless there's very specific reasons for strict preconditions, it should really only be conditional on rents being paid up to the break date, to giving up occupation and leaving no other occupiers in the premises. I could probably do a whole session on those 3 points alone, to be honest, but I suppose for everybody on the call, the point around invoicing rent, again, it's a bit of a techie point, but when we're drafting it, we try to keep it very tightly drafted so that it's just rent that has to be paid and no other charges, because you could have service charge or insurance rent or other top-up payments that the tenant might not just be aware of at that exact moment in time, and their break option may fail, because they've missed a £15 payment of a rent insurance rent top up or something like that. So we try to keep it very tight that it's just rent, and that the rent has to be invoiced before completion, before the break date would be exercised. And also that there would be good time given for that to be paid. So there'd be quite clear parameters, and doesn't have to be paid in cleared funds on the break date, for example, which is something that can sometimes creep into breaks. So yeah, it's just really to flag that point. And often actually what we will say, if we weren't instructed initially and we're reviewing a lease for a client and we see that there's quite a strict break condition and there's none of that sort of wording around rent being invoiced or clarity, we'll say, look, just overpay, and then refund that, get that refunded back after the break. But the difficulty with that is, and it's the last bullet point there was an M&S case against BNP, which is quite a famous case. Lots of lawyers had lots of fun with, it's not just a break clause, it's an M&S break clause and all this type of, there's a lot of articles floating around at the time on it. But M&S really lost 1.1 million in overpaid rent because their lease didn't include a provision whereby after they'd exercised the break, overpaid rent, a service charge and insurance would be refunded. So it's not a space you really want to be in. But I suppose I thought it was worth spending a bit of time on if you're happened to be advising a client and their lease is part of that, and you note that there's a break date there, anything you can do around ensuring that the rent sums, figures, and all of that is very clear what's needed to be paid and is dealt with at the time, will really add such value to the client to make sure, if they're a tenant client, that they're going to be able to exercise the break properly. Let's say on new leases, we're really trying to be very strict and tight on this in terms of keeping it as unconditional as possible and linking back to that code, albeit that it's not directly applicable in Northern Ireland. But it is just an increased area of difficulty. And actually what we're seeing now is, heads of terms used to come in, they would say, a break date at year 5. And then, if you're acting for landlord, you would put conditionality around it. And now we have sort of tenants saying, well, if it just says break date, then that means it's unconditional. And there's actually a lot of pushback around that. So it's just sort of increasingly becoming an issue. And I suppose in the market that we're in, people are they're nervous around taking longer leases and they want to make sure they have flexibility. And breaks are so important that it's becoming, a sort of a big bit of our work. Is really advising around these and trying to get them done properly. Rent review dates then have just included some suggestions from that 2019 code. Again, just if a client happens to ask you because it relates to finance and payments and rent, what does this rent review clause seem fair, or how would that be worked out, or could you do the calculations for us? The code would say that the rent review clause must be very clearly expressed and allow for the rent to be very easily ascertained. The rents to be reviewed on an open market basis, and that's the general sort of backstop and mainstay. That reviewed rent is not to be higher than current market rent, and that no artificial assumptions to be built in and no obscure formulae. So it is a tricky one, and actually it changes quite a lot. When the code came in 2019, the inflationary environment was very different from what it is now, or was in the last sort of 12-18 months. And so there's been quite a shift towards RPI linked increases in rent, which actually at that time seemed okay, but now when we're doing calculations based on what it could be, it maybe seems that if you could have capped it at a figure or put in a particular level, that might have been better. But hindsight's 2020, as they say, and I suppose at the time the code was put in place, this was thought to be the best position. And to be fair, open market should be your backstop on that, and should always be the reference point, so nobody's paying sort of over the odds in terms of rent. And that links back to our business tenancies order, which is very protective of tenants and would not want to see sort of the landlords ripping off tenants on the basis of sort of convoluted rent reviews. Termination date, again, this again, it seems like it's a bit sort of rule 101. If the date on your lease terminates is specified, that's the date that it will end. However, the business tenancies order here would sort of indicate the best practice would be serving 3 months notice. So again, I just wanted to flag, if you have a client who's saying, or my lease is up, I'm looking at my options, and giving a bit of an overview of where the business is going and where their property needs are. It's a bit of value add to say, look, you might want to speak to your solicitor, but you've probably best serving notice in any event. And then linking on to sort of considering dilapidations liability. Even very sophisticated clients of mine can be so shocked when it comes to the end of the lease and the dilapidations schedule comes in and it's so high and it's such a horse trade around it. I'm doing a lease at the moment, and I was sort of giving a bit of an indication around what dilapidations liabilities may be at the end of the lease, and sharing a few sort of horror stories. And I said the worst one I ever had was a schedule of condition that came in with a £4,000 cost to remove a sticky mark from a bench. And that was a genuine cost estimate around. It was sort of leakage from a printing machine that had left sort of a sticky stain on a wooden bench, but it was a £4,000 cost that the landlord was suggesting to remove that, which is utterly ridiculous, but that was a genuine claim. And so, anything we can do at the start of a lease to kind of tell clients that this is a risk, that this is, it should just be built in as a cost of their operations, as a property cost. I'm not sure to the extent that's done. I'm sure many of you listening, if you're advising clients, you would be asking them to include that as a cost, and to build that in. But so often we get to the end of leases, and even very large and sophisticated clients are just shocked at the costs that emerge from that. In terms of mitigating factors around the lapse, whether you preempt a schedule being served and get your own survey undertaken. I mean, some clients even consider undertaking some repairs to limit the dilapidations liability, but I've never really seen that work to any great effect, to be honest. So just considering these things at the time that the lease is coming up, and even if all you do is sort of forewarn that there could be a big claim coming from the landlord, but look, don't worry, it'll just be a bit of a horse trade and you'll get to some agreed settlement at some point. It might be enough to add a bit of value to a nervous tenant who otherwise comes to us and then is really shocked that they've been served with a schedule with a huge sum on it. Again, coming up to termination date, if the tenant is keen to remain in the premises, if it's particularly key to them in terms of location, if they're in retail or office warehousing, anything, I suppose, where location is really important, they might want to consider their options to renew, versus any BTO applications they might want to make. I suppose what we would usually say is if there is an option to renew in a lease, and I'll come on to it now, it's better to pursue that if you can, rather than rely on business tenancies application down the line. The tribunal would take the view that if there is an option to renew and you've sort of just not exhausted that, then you shouldn't really be at their door having not exhausted another option. The other thing I've just flagged there is that if our plans are keen to renew, now is the time to consider the terms, to look back over the lease and come back to this sort of forecasting and milestones, looking back and saying where the pinch points were, where the difficulties were, particularly around rent review or breaks, and what variations you might want to make. If you're signing up to stay on, the landlord doesn't have to re-advertise. They're saving costs on that. They have you as a guaranteed tenant for another period of time. It's the time that they can make concessions, particularly if there's something that they also would appreciate was difficult in the initial term. I've just mentioned that RPI, sort of CPI point on rent review there, and also caps and collars. When I first qualified, rent review caps, service charge caps, and collars were really, really common. So maximum, minimum levels were really common in leases, and we rarely see them anymore. And when I get on to the ESG point, I would just be making the point that caps could be really useful there. So options to renew, again, if there's conditionality there, it's a bit like the break notice. If there's a time frame or there are conditions to be dealt with, it's important to do those properly and to deal with them in the same way as you would almost treat a break. When I was mentioning pedantry and the break options, there's a famous case that said, if a notice was to be served on pink paper and you served it on blue, it's invalid. It should have been served on pink. So if there is conditionality around the option and how that's requested, make sure that that's followed. And again, I mention it now because often a client would come to us until after they've already maybe tried themselves on the renewal process, or they've missed it. So it's just if you're at a point where you're advising them generally, you could catch it at that early stage. I've said carefully consider the terms proposed. I've been dealing with a few recently where more so options to purchase than options to renew, but the terms that were proposed when the option was originally granted at the start of the lease, they just don't stack up, in today's environment, and therefore you have to carefully consider, yes, when we entered into it, this was the hope, this was the intention that we would renew or buy or whatever. But those terms might just not stack up, and I think sometimes clients think because they agreed it maybe 10 years ago, they want to either honor that, or they think that was the right thing to do then, it must be now. And it's just good to take a step back and think about it in the round and make sure, is it really the best option? Also, there, is it better to wait and see with the business tenancies order to fall back on? It comes back to my point on the last slide. The Lands Tribunal, which administer the business tenancy order, they don't really want to be bothered with applications that could have been dealt with between parties, and there's a level of efficiency there that you'd have to admit is better to try and agree between parties. But in the odd occasion, it's possibly better just to let your time run out on your option. And then, when you go to the tribunal, you just say, look, unfortunately, we missed our time period. We weren't on top of it. And that's why we're sort of coming back to you. So there's sort of different scenarios for different things. But obviously, depends on the client, depends on the situation. And, obviously, we're happy to advise in that scenario, but it's important just to try and consider all options at that point. Preemption rights, I've mentioned this really because when I was chatting through break dates there, you sort of conspicuous by absence is the reference to a landlord's break. Really, breaks are for tenants. There's a bit of a mixed view on this in the Belfast market particularly. Some firms will say there's no such thing as a landlord's break because of our business tenancies order, which we'll come on to. Others say you can include a landlord's break as long as it complies with business tenancies. But one way to sort of circumvent that we've seen mostly in shopping centre leases, to be fair, rather than just sort of generally used or sort of preemption rights. And I've just flagged this because if there are landlord preemption rights, so the landlord has the right, if your tenant client wants to surrender or leave the premises, that the landlord can sort of preempt, take that back, and circumvent the business tenancies order. I have concerns over the enforceability around that, and I would suppose if either tenant or landlord client wanted to rely on that, I would find it a bit difficult. So I just wanted to flag it because, as I say, we mostly see them in shopping centres, but the odd one will creep up where maybe a solicitor has done some work in a shopping centre, thought that's quite a nice idea to circumvent business tenancies, and brings it into another agreement. And it just needs to be very carefully considered. If it's a tenant right of preemption, then it just needs to be considered as, again, looking at the deal as a whole, and is there a possibility to offset the rent that's been paid previously as a deposit or rent deposit if you have a guarantee previously. So it would be just to try and maximize the use of the preemption. If the tenant has the right to call for a new lease or to buy, could they offset some of the rent paid as a deposit, or agree a reduced purchase price on that basis? Could they look at taking a renewal lease but on much more favorable terms, even if it's over a longer period of time, but building in more favorable tenant breaks? So it's really just those type of things, again, just thinking that you might be more at the cold face of these kind of discussions than we are necessarily before heads of terms land with us. So the business tenancy order, there's a lot of sort of information on that slide, but I just more so because I wanted you to have it with this slide deck rather than to go through it all in this session. It was just a flag if you have English clients who are operating in England, Wales, or investors who are maybe coming to Northern Ireland for the first time. It is one of the big differences between our property law and the English system. The 1954 Act in England, you can contract out of, so you can contract out of the tenancies protections that we can't here. So it's a very tenant friendly market, and we have no way to sort of circumvent that officially. In England and Wales under the 1954 Act, it can waive that protection, and they have no right to stay on when their tenancy comes to an end. In Northern Ireland, a tenant has the right to request another lease if they've had a term it's been greater than 9 months. And I suppose just a flag on that side there, A to I, are the circumstances where a landlord can oppose such an application by a tenant, but they're very tightly construed, and there's quite a high evidentiary threshold with them as well. For example, the one that we would see most often would be sort of the redevelopment. So F there, that there's an intention to demolish a building or carry out substantial works. If you want to rely on that as landlord, you will have to provide planning permission, building control consents, evidence that you're instructing a building contractor that's gone out to tender. It is quite a high level of proof that has to be provided in order to defeat the tenancy application. And again, if you're advising tenant clients, it's a positive story for them, and it means that, particularly, and that's the reason that we have it, is to protect businesses. So if someone's operating a business and the location and goodwill is so tied up in that location, I think a landlord can't sort of force them to move on. But it is just something to consider, and it's something to think about at various stages in the lease process. Again, coming up to the end of the lease, probably most common. But also if you're agreeing a surrender at some point during the lease, there are obligations to be considered there because you're waiving the protection at that point. So it was really just to flag that, and then again from a financial aspect to flag the compensation point. I feel like this is often forgotten about, even with solicitors, that if the landlord does successfully oppose a new tenancy application, then there is compensation payable. And it's maybe not an open market payment, it's not insignificant either, and the compensation premium and how that's calculated and multiplied is in the second bullet point there, just really for reference. But it is something that I think people are advising landlord clients, saying, well, look, you have grounds under the business tenancy order to get these people out, and they forget to say, but you should maybe just do your compensation calculation as well to see what that would be, because that will be payable to the tenant. And so it's something else that you might be asked to calculate or to consider, and it was just a flag at that point. So that's led me on from business tenancies into negotiating heads of terms. So I suppose thinking about, if you've come to the end of a lease either by agreement, or your client is tenant, they've waived their business tenancies protection, or they've moved on and moved elsewhere. What might be useful in advising your clients as they're saying, we're going to move on, we're going to look for somewhere else, and what should be contained in the heads of terms. The aim of heads of terms are really to get the deal on paper before legal costs are incurred, and that's actually that quote's taken from PLC, which I feel is a bit of a dig at lawyers generally, but it's a point well made in terms of really good heads of terms can just shave so much time off a deal, off agreeing a lease, and so much sort of hassle and sometimes I feel, but if you've had a very difficult lease negotiation, a lot of the goodwill of the landlord-tenant relationship is used up before you've even taken keys. Really good heads of terms, which are really clear, and I've put the last bullet point there, just clarity, clarity, clarity. That really will help and adds value to, this was our advice to clients in terms of protecting their relationships. But I've just put here particularly considering VAT and capital allowances. And again, I thought this is the sort of thing that you're more likely to be brought in or asked to advise on in this type of transaction, or at a point in the transaction. The VAT position, so often we get heads of terms in that say, VAT position TBC or unknown or will confirm, which is fine, except in the circumstances where the deal is predicated on, the landlord making a VAT election. Another side that sort of says, look, that might take 6 to 8 weeks. So if that was sorted out at the time heads were agreed, so heads are agreed, the landlord will make an application to HMRC, and we'll keep the tenant updated or whatever. By the time the lease is agreed, you should have that in place, and it saves a lot of hassle rather than a week before the lease is to be signed, realizing that hasn't been done and having to agree all sorts of various indemnities in the lease around, if the application isn't successful, if VAT is paid incorrectly or an error, etc. As I say in my slide later, it says 6 to 10 weeks or 6 to 8 weeks. I'm dealing with one at the minute that's completing tomorrow. The application was made on the second week in January, and still we have barely got an acknowledgement of it. So it was just to say, I suppose if you are asked to advise a client on VAT generally around property, or when they're looking at new premises or whatever, if that can be clarified at the outset and dealt with at the outset, it does save time, because you don't really have it to play with when it takes so long to hear back from HMRC. And then capital allowances, I wasn't proposing really to go into that in a lot of detail, just to say that I do feel like quite a lot of money is left on the table when it comes to capital allowances. Nine times out of 10, 99 times out of 100, we're reporting on transactions with capital allowances of 0, or entering into section 198 for £1, and actually, I can tell even just from looking at the brochure, the estate agents' brochures, where there is air conditioning, where there is significant plant, there's been significant sort of capital expenditure, and there is a benefit there around dealing with capital allowances properly, but it just doesn't seem to be being picked up as a general point. So again, it's just something where there is sort of money left on the table. There is a benefit to clients in dealing with that properly. And it's something that I would say you'd be more readily asked to advise on than we would. But it's just somewhere again where we could probably add value. Um, just this sort of slide repeats the latter, except to say because heads of terms are not legally binding, if there are pre-contract matters that are meant to be legally binding and those relate to something that you're advising on around confidentiality or exclusivity in a business arrangement, that should be dealt with outside of the heads of terms in order that it is binding and can be relied upon in the parties. Just a quick point on misrepresentation again, because I suppose if I'm asking, if you're involved in heads of terms and I'm asking you to consider particular issues, just a flag that most property contracts do make express provision that limit liability for any pre-contract misrepresentation. So if you get something wrong in heads of terms, it's not the be all and the end all. And I would say better to have more detail and more clarity in the heads, and then for that not to be quite right at that stage, than to leave something out that becomes really key and important to the parties down the line. I've just flagged that Proforce case there, which was actually a pure contract case. It wasn't property, but there was a ruling there that the heads of terms and the pre-contract discussions did form part of the factual matrix. So it is a bit of a I suppose a warning there that yes, they're not legally binding. Yes, like liability is limited, but if there is a dispute scenario, they may be brought in as sort of part of the factual matrix generally. And I've just put a query there: is there a defence if the 2019 code was applied? There's some common training that says, if it's heads of terms for lease arrangements and you've applied the code to it, then you've got a bit of a defence in terms of your liability because you've tried to deal with it in accordance with the code. We don't have that here, but whether that would add some weight to say, well, okay, the 2019 code isn't applicable here, but we have good reference to it as general principles, whether that would assist. And then just really before I sort of close up, I just really wanted to focus on the ESG impact. And as I said at the outset of my introduction, in previous seminars, I'd focused on very different risks around this. And I suppose in the property world, the ESG sort of buzzword that's been about, we haven't really thought how that would be generally applicable to us in our role and what we do day to day. But there's sort of increasing noise about this. And I sort of laughed to myself because the MEES regs, the minimum energy efficiency standard, they came into Northern Ireland, or came into England and Wales, sorry, when they were first enacted. Lots of firms in Northern Ireland did various articles around them and sort of said, oh, look, these have come into England and Wales, they're probably coming to us, and what would the impact be? And then nothing really happened, and they were just kind of, those articles are periodically, reran again with, oh, this might be coming down the tracks, but nothing has ever really been construed. But there's just more and more discussion about it, and we had a seminar around at one of the bigger agents in town last week. And they were just seeing it more and more coming in by the back door. So I suppose to give background and context, the MEES regulations really are those that say landlords can't continue to let buildings that have an EPC rating of less than an E rating. And that's quite a low rating. We wouldn't see that too often, but it's increasing now, and there's thought that would be moving up to sort of D and then possibly C. And whilst that's legislation only applicable in England and Wales, what is happening is lots of institutional investors or some of the big sort of finance houses or funders are saying, well, look, if that's applicable and going to be applicable going forward and is important for our own ESG or climate change strategies or whatever, then we want to see that as part of our standard documentation. We want to see risk assessments around that. We want to see that in our leases. And so actually where that's going to be a real problem in Northern Ireland is there isn't a huge amount of grade A office space around which would be compliant with these regulations if they were brought in, or if it was sort of tenant demand driven, where they were sort of applied just by tenants by virtue of requirement rather than statute. And I suppose the fear is that you'll have maybe lots of tenants who are backed by big institutional investors or funders coming to the end of their leases in the next couple of years, and those investors, funders will be saying, well, you can't stay in a building that has, a poor energy efficiency rating, of which there's so many in Northern Ireland and so few actually at the top end of that scale. So there'll be a bit of a drive to then move to more energy efficient buildings. But obviously not everyone is going to be able to do that and comply with that. So what happens with the old stock that's behind that needs to be re-geared, repurposed, insulation and all that type of thing. And I suppose one of our fears and something we've just really thought about over the last really couple of weeks is around service charge and how, if we're starting to see this as a concern coming from tenants, landlords will also be concerned that they're going to have lots of tenants exiting buildings because they're not up to standard in years to come. And so is there a possibility that they might start now and they might start looking at ways to upgrade and increase energy efficiency, which obviously is a good thing, but the way our leases would be drafted would usually indicate that if the landlord has to spend money complying with something that's either enshrined in statute or for the general good of the building, or in the principles of good estate management, that can be passed on via service charge to tenants. And it's going back to my earlier point about caps on service charge. For so long we haven't had those, and I really think we need to move back to those, or move back to some greater interrogation of service charge and service charge exclusions, to make sure that we don't have a situation when you're acting for tenants where landlords are able to charge huge amounts of money to upgrade buildings for energy standards and then pass that cost on, and because ultimately that landlord may spend that money on the upgrades, but that might still not be enough for you as tenant if you have international investors or you're part of a wider corporation. Even the agents we were talking to are part of a wider sort of worldwide group, and they were saying their own group requirements, from outside of the Belfast office would indicate that their current building, wouldn't meet those standards. And if the company took a decision to say every office across the world must have a minimum standard, then they would have to move. So it is that type of thing that, without sort of scaremongering, it does seem to be on the horizon. And I know some of my colleagues in the banking sector were over in London at a conference a few weeks ago, and it's even gone beyond ESG there. There's lots of other different standards around water recycling and other environmental impact issues, where again buildings where people spend their time either in offices or shops or whatever need to be of a particular standard, and there's a cost to bring them up to standard. So it's really just a flag that is something that's in the background, and whether we're going to say it's coming down the tracks, I'm not sure we go as far as that, but it's certainly something that I'm starting to think about in my drafting and in my advice, just to make sure that tenant clients are protected around that, and also that landlord clients are aware that this might be something that they need to deal with, or otherwise face the loss of tenants, particularly if your tenant mix is of a international type of business. So really just flagging there that there's a lot of lender-driven change. As I said, some of my banking colleagues were in London at a lenders conference, and there was a lot of talk around where there's an issue for lenders where a building doesn't meet minimum requirements in England. Again, there's no legislative requirement here, but if it is a lender-driven requirement, that's where it can cause a difficulty. Or if they have to take possession of a property and then they're subject to the regulations in England, again, those aren't applicable here, but if they're subject to their own internal regulations, then that becomes a difficulty. So it's really just, we're hearing more and more of that in the market, and something to be aware of. Last thing I just wanted to touch on was just around timings, because I think, again, presuming that you're involved with your client's business strategy, business planning, thoughts around, property strategy or costs that are going to be incurred in taking new leases or moving premises, there are some delaying factors that we see quite a lot, and it's again just around adding value. If you're able to sort of tell your client that there might be these possible roadblocks, stumbling blocks, or time stealers in the deal, and to sort of preempt them. So I've just flagged a few things here. Property certificates, which we need in quite a lot of transactions, which come from sort of local councils and confirm planning permission is in place, etc. They're taking about 3 weeks to come. And so, if you're going to hit the button on something, but you have a bit of time, and you're happy to incur the costs initially, you could reach out initially to this lister and say, look, could you get a title pack together and get property certificates? And that shaves some time off. I mentioned that VAT election point from HMRC, yeah, 6 to 12 weeks I've said there, and as I mentioned, currently waiting on one from sort of January. Landlord's consent, that's really about superior landlord's consent. Often if you're taking a lease for a tenant and the landlord is X, it's good to remember that they might have a superior landlord in the background or a lender that needs to consent if there are any consents that are required that are outside of the landlord's pure control, to get those initiated as soon as possible. Just mentioned permitted use as well there. If there are planning requirements around permitted use, that's started and that time frame is taken into consideration. Noted breaks there. We've talked about them more or less at length in terms of conditionality and trying to keep that as limited as possible. And then covenant strength. If you're acting for landlord and you're advising them to grant lease to a tenant, to make sure that they're of a sufficient covenant strength, and try and do your DD on that as early as possible. And then the agreement for lease point was really just to link back to my sort of first slide around term commencement of when access is taken. Quite often under agreement for lease, there's so much conditionality, so many moving parts, that it's quite easy for a tenant to take access slightly early for good reason or otherwise, and then that impact on term commencement and stamp duty payments. So it was really just to flag those as kind of key takeaways in terms of timing, and where maybe you can add value just by giving a heads up to sort of help sort of grease the wheels of the transaction, if you like. So it was really the end of what I wanted to run through just on commercial leases today, but happy to take any questions for the next few minutes.
Thanks, John. We'll have to make sure we have you penciled in again for early 2028 to remind us all about the leap year pitfalls. So folks, if you've any questions, please do add them into the Q&A box. But John, one or two to get you started. What would be your key tips for anyone negotiating a new lease or a lease extension?
I think just it's very hard always to sort of future gaze and think, what do I need in 10 years' time? But I think by virtue of that, then what you should be trying to do is maybe take a shorter term view of your requirements. And I think, as I mentioned, building in as much flexibility as possible, flexibility for breaks. Whilst I spend a bit of time explaining how difficult they can be to exercise, even having that as a threat to then say, look, we're going to exercise this unless we can vary our lease. And this obviously come from a tenant's perspective, but building in that flexibility and even those milestones that you can have those conversations with a landlord, and try to work out what's the best way. I mean, ultimately in this market, the landlord wants to keep the tenant, wants to keep the rent coming in, and so to work collaboratively. Sometimes to get into lease is the easy bit, but then after that it can be difficult. So as much flexibility as you can get away with is the top tip on that.
Okay. And what would be your number one concern then for tenants just now?
At the minute, it probably is the ESG point, and I know we've probably laboured that as well, but it's just something that we hadn't really thought about as an industry. It's one of those things that's been in the background for so long, and I suppose we've thought, there hasn't been any government push on it, but actually where we've kind of found it is, as I said, with lenders or with institutional investors, like lots of us who are part of organizations with offices in other parts of the world, you're really heavy on this type of stuff. And whether we think it's important or not, there are going to be requirements that need to be dealt with. And I suppose my fear for tenants is that if you have a lease with no service charge exclusions and no cap, and you have a landlord who's alive to this and knows that they're going to need to upgrade their building, that there's the potential for a lot of costs to come your way in service charge. And there's no real way to get out ahead of that except to maybe be aware of it and try and start conversations early.
Okay, thanks, John. One further question, I suppose around break notices again. I mean, what would be the biggest risk factors you would see around exercising those?
Well, probably the biggest risk is usually on the lawyers, which you'd be glad to hear, because actually the most mistakes come from the simple things, as is always the way in life, which is the addressee not being correct or not being correctly served in accordance with the lease, or not going by the right registered post or recorded delivery or whatever. So actually those are where loads of the risks arise. But generally a lot of those risks sort of land on our desk because we don't have enough time to consider everything. So I suppose if but one like request of tenants would be, don't leave it to the last minute, but it's inevitable. And I suppose that's kind of where this topic came from, is if you can get out ahead of where milestone dates are on your lease and know well ahead of time, you can have a strategy. Like quite often, it tends to always happen on a Friday. Someone will say, I have a break notice that needs to be served. It needs to be served before X date. And then when you look at it, Sunday or something is the date. So you have to get it out on Friday by next day delivery. So, yeah, the main risk is around not serving correctly. And then the secondary risk is around the payment of rent, which is kind of why I labored that point too, and why
Yeah.
we try to say, if you can get clarity on what's payable and an invoice and a sort of a agreed structure around invoices issued and then is discharged before the break date and all of that, that's the best case scenario and limits most of the risk.
Okay, John, there are no further questions. I think really the key message taken away there is clarity and timing. And having that pink paper ready to hand.
Yeah, we do have some good laughs, I think, around some of the cases are quite a lot of pedantic detail around, and you do get lots of funny stories around pink and blue paper and how to serve things. But yeah, clarity is the key, I suppose, with most things.
Okay, well, listen, thanks, John. We're pretty much at time now. There are no further questions in, so just thanks again for your time, and hopefully everybody has found something there to take away. So we'll just close the session there.
No problem.
Have a good day, everybody. Thank you.
Thanks.